What's up, everybody? Welcome back into another episode of The Lawyer You Know. We're in vacation mode still, but things are happening. And Lori Vallow had a hearing yesterday, so we get to hear her argue again in court. And she actually does some things and says some things that make me think this might actually be the best pro se performance we've seen yet since I started covering YouTube cases. And I'll tell you why. We'll see if it's right. We'll see. Let me know in the chat if you guys agree or disagree. We also get some information about her testifying and what that will look like and why it may be different than some of the other pro se defendants we've seen in the past. And why does the judge keep asking her if she wants a continuance? We'll get to all that and more in today's video. Make sure you guys hit the like button and make sure you're subscribed to the channel. So we start out with the judge allowing the investigator for Lori Vallow to sit at counsel table with her. They talk about the jury questionnaire a little bit, but we start to get into the arguments that Lori Vallow is making. She still wants a video that the state, she says, won't give it. The state says it doesn't exist. We hear this all the time in cases, so we're going to listen to that argument a little bit. And then we're going to discuss some of the issues that may cause a delay in the case, and we'll see the judge kind of push. Do you want a continuance? Does that mean you want a continuance? Well, you don't want to continue the case. And she's filing motions. She's adding witnesses on the witness list. She's doing things late, but she is doing things. And the judge provides the remedy of a continuance multiple times. So we'll see some of these interactions in court, react to them, and see what we can learn about how she's going to handle this case.
We're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it.
A mitigator.
A mitigator.
Showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed.
I will tell you why they won't, because that is my former team and they will not do anything to help my investigator.
So that was an interesting revelation that her former team, I believe she means in Arizona, I guess she could mean the Idaho team, but I think she means in Arizona, will not help her, will not provide her information, which they can't do. Like, they have to provide her that information. It's her case file. It's her information. It's not like they can keep their notes and their work product and things like that, but we'll see how the judge deals with this. I think he deals with it perfectly, but that was a revelation. That was interesting. That explains some potential break in the relationship, and I'm sure a lot of us can imagine why, but I thought that was really interesting, and it shouldn't happen. It shouldn't happen to Lori Vallow. It shouldn't happen to anybody. Listen, she's a convicted killer at this point, but she's presumed innocent on these charges. She should get a fair trial on these charges.
My paralegal, they won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help.
And if there's a conflict, that's fine. Don't talk about the case. Don't share information. Don't talk to them at all. But you still send them everything. You still send them everything with a letter.
Yes, they will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right. Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you, or did you have to start from scratch?
No, from what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn on any notes, any work product, nothing that they had done to that point.
So there's definitely stuff they don't have to turn over, certain things, but like a list of exhibits that exist. If they had the video, they have to turn over that video. They have a link to that video. They have to turn over that video. They can't just keep that stuff away from Lori Vallow. Now, is it on the 22 terabytes or whatever they turned over? Maybe. Is she trying to find a needle in a haystack? Maybe. But that's not how it should be for a defendant in Vallow's situation.
And they continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
it's also very difficult for an in custody defendant trying to do stuff like this and stay on top. And you give somebody a list of things that you know at the time, they won't give it back to you later. And it's like, I don't remember what all I told you. You were supposed to keep those notes, but are those technically work product? That type of stuff, in my opinion, should be turned over. Now, if the attorney said, you know, I'm prepping this depo and these are the questions I'm going to ask or whatever, that's work product they should keep.
All right, I'm gonna make an order and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council. To makes Hicks, you look like you want to say something.
I don't know.
So he makes an order and he discusses it again later. He's going to tell him to turn over everything that is not appropriately protected. And he even talks to Vallow about how I can tailor it to really get you what you want, but also to get you everything. Because she's like, it would be nice if I could actually have my entire file. All right, now we're going to jump ahead to her discussing her witness list and the state saying, well, we need to have time to depose these people potentially or talk to them. So we'll listen to this now.
To make sure that this is the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one.
And I can understand her frustration there as well. To act like this is a big deal and this is a delay and you don't know what these witnesses are going to say when you've already interviewed all of them and I got them from your list. Sometimes this is a situation where the state can sit there and gaslight a little bit, right? And be like, Judge, we have the opportunity to talk to those people. We don't even know. Her witness list is late. It's like, come on. If she got them from your witness list and your people you've already interviewed, it's like, that's just how it goes. But they're entitled to play by the rules, and they're doing it. But if this was a defense lawyer, they'd be like, come on, Judge. They've already interviewed anybody. Where's the prejudice? Explain to me where the prejudice is for this witness list being late. These are people I got from their file. These are people that I got from their interview list, their witness list, people they've already spoken to outside of one. Now, that one is a big deal, and we need to make sure they have the opportunity to interview that one that she's added to the witness list. We find out more information about who that is. I think that's a good argument by Lori Vallow. And these types of arguments and the types of things she says and when she pipes in, people are going to find it very annoying, I'm sure. But to me, it's the best we've seen from a pro se defendant, which isn't saying much, but it also is absolutely the most help I have seen a pro se defendant get from standby counsel, from an investigator, from a paralegal. They have put a team around her that is willing and able and seemingly is helping her throughout the process. That makes all the difference in the world.
Which is who?
Which is Nate Eaton.
Okay.
And we all know our boy Nate Eaton, East Idaho News. He's on the witness list. State hasn't interviewed him. I'm positive he will be very willing to work with the state. He will be a friendly witness to the state. So I'm sure he'll talk to them. I'm sure he'll give them whatever information he needs. He ain't going to hide anything for Lori Vallow. And I can only imagine what she's going to ask him. We're going to see. This trial is going to be interesting. It's going to be different. This trial is definitely going to be different than the Idaho trials.
When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
Well, the case law says the prosecutors the police are the agents of the state. So it's all the state, but I get his question. She may not know the distinction. Is this a prosecutor? Is this an investigator? Somebody who works for the prosecutor's office, works for law enforcement, whatever it may be. So I don't really think she has to answer this or needs to have this answer. The point is that team over there has already interviewed these people, so they know what they're going to say. So there's no prejudice to them being on a late witness list or them being on my witness list at all.
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand that I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
To me, it's a better version of Sarah Boone, right? It's a better version of Sarah Boone and how she's arguing this.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these
Well,
people?
Your Honor, the
They may be
first listed
referenced.
person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
That's our guy, Nate Eaton.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405.
So these are two different arguments now, right? Are they improper witnesses? Are they not going to testify to anything that's relevant or admissible? Fine. But the whole, like, we haven't interviewed them in 5 years. It's like, okay, so try to interview them. Or that still means you've interviewed them, right? So it's like, I do think she's being a little difficult here on purpose, but that happens in pro se cases, especially if you feel like pro ses are doing things well. The prosecutors usually are a little bit more difficult. But her disposition is perfect. Calm, cool, collected, not going to argue, not going to get in the mud, not going to sling things. That is a disposition that usually is in contrast to how a pro se defendant can get really worked up. And while I think Lori Vallow is doing okay with the judge, it's a whole different ballgame in front of a jury.
So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today.
But also you can use their interview from 5 years ago to say they're a character witness. They have nothing relevant to testify or nothing admissible to testify. You don't have to interview them again to file that motion. You can file it based on what their prior statement was, because their prior statement is also what Lori Vallow is going off of.
The state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute out there as to whether or not they'd be called, I'll have to deal with that as it comes up.
Well-
But if they're unable to be located or interviewed, obviously they won't be called at trial. Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th
Well,
from OPDS.
you're the one pressing for your speedy trial, so you kind of have to make a decision on.
So this is when the judge starts to kind of hold her speedy trial against her. I don't like when judges or prosecutors do that. She's also requesting things as quick as she can. In January, it took them almost 2 months to approve it. That's too long, in my opinion, but the wheels of the government move slow. And this is why the process, to me, even for somebody like Lori Vallow, I'm going to fight for it to be fair. And it just seems so unfair when you only have a few months, right, for a speedy trial, and it takes them a few months to get anything approved. And then the judge says it could take a few months for them to do the work that you want to do to present a proper defense. And the judge is like, so basically at this point, you can either choose a good defense or a speedy trial, but you can't have both. And Lori Vallow, being who she is and a pro se defendant, is like, I want the speedy trial. She thinks that's the best. It kind of worked in the first trial, if you want to say. She got some benefit from pushing for a speedy trial when they removed the death penalty. So that's what she's going to go with again. But she's also kind of laying a record like, I'm doing what I can, judge, and they're just not providing the information I need, or it's taking too slow. I'm hoping it can be expedited. potentially, I'm just saying, I think an appellate lawyer will look at this and be like, we've got some potential appellate issues here.
And we're set for trial. You want to go to trial, or you want to have him do that work that you want? Because I don't think both are going to happen. Even if you got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that. And I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late technically, but if it were allowed, first of all, it's going to take time to coordinate him getting let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone, Charles Vallow's phone. And I would like.
So the first time I heard this, I literally thought she was talking about Chad Daybell's phone. And then I had to go back and listen and realize she's talking about Charles Vallow's phone. So I was like, why would she want Daybell's phone? But you know, in the life of Lori Vallow, it's going to take some explaining to this jury about how we got here and what has happened since, because some of that's going to become relevant, and we'll hear how it may become even more relevant if she testifies.
Copy of the extraction that they took from it, the digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on a 22 terabyte. So if hard drive. So if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the cell-right extraction already for that requested item that's been in defense possession for however long now.
I'll take it up tomorrow.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
So once again, he's like, are you sure? You don't want to, because any continuance or I agree to not proceed to trial at the end of this month means waiver of speedy trial. That's the only way she can do it. So it feels like to me, they keep having this discussion. You sure you don't want to waive speedy trial? You sure you don't want to waive speedy trial? Because everybody's life gets easier if she waives speedy trial. Then we can take our time. We can do everything we need to do. The state can do everything they need to do. There's two different trials. Lori Vallow can get her defense experts, and it gets rid of some appellate issues. So all of that kind of goes away if she just waives her speedy trial. But she holds that as if it's a trump card. Doesn't mean you're going to win, right? Just like in a reverse trial. Actually, a lot of times you lose if you push it too fast and you can't prepare a good defense, but it does create appellate issues.
Okay.
And she says, yes, I'm positive I want to proceed with trial.
At the end of this month?
Yes, Your Honor.
Okay.
Your Honor, I would ask leave that depending on what Mr. Dorkin says, that
Well,
would
it
put
could
this,
still be precluded because depending on what his opinion is, first of all, it's late under the rules of evidence and rules of disclosure. And secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well.
It's late under the rules of evidence. I don't really know what that means, but it's late based on the judge's order or the disclosure time periods and the deadlines. And the judge is saying, like, even after he does this, I could still, like, he could do all of his work. It could take months. We could continue the trial and I could still strike him because either he was late or for whatever reason the state comes up with to strike him. Or if I don't strike him, I have to give the state time to respond and potentially get their own expert to have a little battle of the experts here. So the timing of this is very difficult. And the fact is, I may just strike him for being a late disclosure anyways, because I can't, the state has a right to a fair trial as well. And if the timing does not give them the opportunity to do their expert work, then bada bing, bada bang, it's not happening. He's not testifying. He's not part of this trial.
So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
More than a year, Your Honor.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January and last Friday, he got approved.
But she's had it for over a year, so she should have done it earlier. Again, pro se defendant. Things don't happen quickly, but it is what it is. That's why we're here.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense.
Again, he says, are you sure you don't want a continuance, Ms. Vallow?
Do the work that you want done on your defense. But if you're telling me you don't want to do that,
I would like to do that, but my situation in my housing department precludes me from doing that.
from asking for a continuance,
No, from getting things done in an effective and quick manner.
And I think that she's not necessarily using the perfect terminology, but she is keeping all the appellate issues open. Because he's like, well, you can either have your defense or you can have your speedy trial. And she's like, I understand that, but I can't have my defense because of my housing situation. I can't have my defense because of how slow things move. And I'm going to have my speedy trial.
all right, well, so you're telling me you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Okay. So I guess I'm gonna have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Honor, we have a little over a week to try to interview these people, so I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also,
But I think if they've already had the opportunity to interview these people, they already knew about these people. I don't think they should be struck just because the state wasn't able to interview them again when they were in their possession, interviewed by law enforcement, and the defense put them on their witness list a little late. It's the way I would do it, protect the defendant's rights, but we'll see what this judge does.
also obviously asked to preclude them regardless,
Right.
based upon what they may say.
All right. What else do we need to address today then?
So now they're about to talk about if Lori Vallow testifies, what will that look like? We've talked about narrative. Usually when you represent yourself, you just take the stand, you talk. Not in this case, not in this jurisdiction, or at least not with this judge.
From
Your Honor,
the-
the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I don't know if we
609 motion is to talk about the criminal history. So obviously Lori Vallow has some criminal history, and that's going to come out if she testifies. It may come out even if she doesn't testify, depending on some different scenarios. The judge kind of mentioned that earlier, how that might come out. But now they're going to discuss, if she testifies. And she says, I presume the defendant is going to testify. She could. Some defendants like to go pro se so they can say what they want in the questioning and throughout the trial. Some do it because they want to take the stand. We saw Darrell Brooks do it and not take the stand. We saw Tellis do partially and take the stand. So we've seen it kind of done both ways.
wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions. But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions as opposed to what the nature of the conviction are, but that would be up to you whether you want that information out or not. And then the jury would receive a
So they need to discuss exactly how they're going to say it. How can we pacify it? How can we clarify it? Because that information is likely to come out, the judge said.
limiting instruction that whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility.
So it's like, this is the discussion where you can say, how many felonies have you been convicted of? 2, 3, 5, whatever it is. Sometimes people want, like the defense wants the jury to know what these convictions are. It's like Grand Theft Auto when I was 18, and it was like, I was stupid. I was a kid, whatever. So you kind of explain it away. It was 50 years ago, whatever. But when it's killing your children, usually you're not going to want the details of that to come out. So my guess is she's going to try to pacify it as much as possible, just answer the number of felonies, because it just goes to her credibility. Can we believe somebody that's been convicted of all these felonies? Because if they hear about the nature and the details of the crimes for which she's been convicted, it's probably going to be prejudicial, as it should be, which is not what's supposed to happen in a separate case, separate charge. They aren't supposed to say, well, because you did this, then you likely did this, right? Because you did that, I should say, and you've been convicted of that, you likely did this, which is in a similar vein, just to a different person, right? We don't want that in the justice system. So if you're going to take the stand and we're going to talk about your credibility, it's just usually how many felonies have you been convicted of, more crimes of moral turpitude, things like that. But that's something they're going to discuss on another day.
So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory counsels ask those questions to you when you're on the witness stand.
So it won't be narrative. She'll be sitting on the witness stand. She'll provide a list of questions to advisory counsel. I think only advisory counsel. It almost made it seem like she's got to give her list of questions to somebody else as well. She gives them to advisory counsel. They ask those questions. She gives her answers. It looks like a normal direct examination. Then she gets crossed. Then on redirect, it becomes a gray area. Does she get to give a narrative on redirect? Does her advisory counsel get to come up with questions on redirect? Does she get a break? Like maybe the judge will give him a break after cross-examination where she can have 10 minutes to write out all the questions she wants to be asked on redirect. She should get some kind of opportunity for redirect still. But kind of an interesting format and way of doing things. Every jurisdiction, every judge is a little bit different on how they handle these unusual circumstances.
Right.
Okay, so you can't take the witness stand and just give a narrative. It'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And ask for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response. I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium. We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory counsels will approach witnesses with exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing.
And that's exactly what we said last video. That's what we expected. He didn't mention it in the last hearing. He does mention it here, which is good. That's exactly how it should be. Vallow says she has some motions she wants to file. We're going to jump ahead to near the end where she asks for more clarification on the order regarding former counsel, former defense team's file. And we'll hear the discussion. It's just interesting to hear Lori Vallow argue.
Just in case anyone is called from that list, and if anyone knows any of those people, I will put that in actually. Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have. So I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told to you secondhand or showed to you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they hand over all those things to you, so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council or who?
Who do you want me to, I was gonna say give it to your advisory council. Do you want a more narrowed order? Maybe any mitigation work that was collected, or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on.
I was just thinking
together.
it would be easier for you maybe to find that needle in a haystack if it was a more narrow order.
Well, she knows what the link is and she could just give it to us, and we asked for her to do that, and
What's that?
the attorney said, no, she can't do that. She can't give you any.
What's that mitigator's name?
My mitigator's name, Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
All right, I'll make a specific reference to that.
And do we need an order, Your Honor, to pick up my husband's phone at Chandler Police so that Lonnie can do the extraction?
Well, you already have that extraction.
Like that, just to me, she's shown a note. She makes a very clear, well understood, well articulated statement to the judge asking for exactly what she wants. She's about to ask the judge, what's the process or procedure for that? To me, it seems pretty polished for a pro se defendant, especially in comparison with what we've seen. Now, again, this is in front of a judge making kind of arguments, legal arguments. Doesn't matter if you say something wrong. The judge knows what you're talking about. Very different in front of a jury, but still, from my perspective, pretty good start.
In your discovery, what's the state's position on Lonnie Dworkin meeting someone at, you said Chandler, right? Chandler
Yes, at
Police
Chandler Police
Department to do another extraction.
Your Honor, obviously the state and defense have always had stipulations so that should something happen to the device while it's in the possession of Mr. Dworkin, that there are now no issues with chain of custody or anything else. So the state would have to draw up a release, have that scheduled on who it's going to be picking it up, have the defendant sign that release indicating that she understands that should anything happen to that she waives those rights to claim those things. So
I think what I was asking was, does Mr. Dworkin have the ability to just do the extraction on site?
on site where? At Chandler?
At Chandler.
I don't think the police departments allow anyone to go in there and conduct their work in the police department.
Okay. All right, so to maintain the chain of custody, the state can draw up an agreement, and if the defendant signs that agreement, then Mr. Dworkin could pick up that phone.
That's perfect. Logistically, how's that going to happen?
She's gonna forward that to your investigator, and I guess he'll have to come down and have you sign it.
Okay.
All right.
All right. And that's it. She's asking some good questions, getting what she needs. Hopefully she'll be able to prepare her defense as best as she can to have her speedy trial. We'll see if it makes a difference in what the jury ends up finding at the end of the day. But we are pushing towards this trial. She is not going to continue this trial. She wants a speedy trial. Let me know what you guys think. Do you think she did well? Not do you like her? Not do you think she's a good person? Nothing like that. Just in comparison with the other pro se defendants we've seen. How would you rank her? How would you compare? That's what I'm interested in, because you guys are potential jurors. The jurors are going to be the one evaluating her. What do you think? What do you feel so far as you've seen her act in court? And seems like she's going to testify. We'll see. Make sure you guys hit the like button. Thanks for being with me today. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.